Civil Judge Junior Division and Law Examinations in English language. Law of Evidence Preliminary Section 1 to 4 of the Indian Evidence Act 1872. That is, evidence, meaning, definition, kinds, nature, and scope is the topic for discussion today. Dear friends, this topic I uploaded in Telugu language few days back, and this subject, law of evidence, that is Indian Evidence Act, uh, brief summary of the subject in detail I delivered in 3 classes long back. You may make use of those 3 lectures to know the summary in detail. For this 2 days, few days back also, I gave the summary of this Evidence Act from first section to last section. Now we are dealing with Indian Evidence Act only. The new act will be the successful implementation of new act will be fructified shortly, because the new enactment Bharatiya Sakshya Adhiniyam 2023 was passed recently, that is in the middle of the academic year. So every Center of Legal Education and Competitive Exam Centers following this Indian Evidence Act 1872. That is why I started uploading these lectures in Indian Evidence Act. In this lecture, I will explain you preliminary of Indian Evidence Act 1872. Preliminary containing 4 sections. Part 1. How many sections or parts, all these things I explained in previous lecture summary. In this lecture, I will take up preliminary, that is section 1 to 4. Section 1, title extent application. Section 2, repeal of enactments. Section 3, interpretation clause covering near 20 words and expressions used in the act and their definitions tentatively. And section 4, we discuss may presume, shall presume, and conclusive proof. Dear friends, I already told long back the Indian Evidence Act was passed in the year 1872, 1872, and came into force on 1st September 1872. At the time of passing of Indian Evidence Act, it contained 167 sections divided into 11 chapters, and also schedule containing some statutes and enactments, information relating to statutes and enactments during the British period. That means at the time of passing of this act, there were 167 sections divided into 11 chapters and one schedule. Schedule, so many subjects who are codified may contain schedule at the end of last section, after last section of the code, or for Indian Constitution there are 12 schedules. Criminal Procedure Code, their schedules are there. IPC schedules are not there. Indian Evidence Act, from the beginning there was one schedule. Of course it is repealed now, and these aspects I tell you. In the schedules, for example, Constitution schedule contains what are the various territories in country, how many states are there, how many union territories are there, and what are the various languages, what is union list, central list, union list, state list, concurrent list, like that. For criminal CRPC, the schedules contain what are bailable offences, what are non-bailable offences, what are cognizable offences, what are non-cognizable offences. Similarly, so like that, So some enactments at the end of last section, after last section, say schedules may be given. Some subjects schedules may not be given. Like that, this Indian Evidence Act, there was one schedule. Of course, it was repealed by Act of 1938, Act number one. These aspects I tell you. Now, dear friends, the Indian Evidence Act at the time of passing contained 167 sections and one schedule. After, in course of time, at the time of by the time it came into force, we did not get we did not have independent India. This act applied to Pakistan, India, and continued after partition of India, Pakistan, and it also extended the act was extended to Bangladesh even after their independence in 1971. So whatever it may be, the Indian Evidence Act contained 167 sections divided into 11 chapters and one schedule. 11 one schedule. Today, the Indian Evidence Act contains 167 sections divided into 11 chapters and no schedule because it was repealed by the repealing Act of 1938. Since the date of enactment to till date, Indian Evidence Act 1872 was amended 28 times. There are 28 amendment acts and adaptation orders which include criminal law amendment acts, Indian Evidence Acts, adaptation orders, and repealing acts also. So, yeah. So, since the enactment of Indian Evidence Act, there are 28 amendment acts as on 31st October 2019. After 2019, the Indian Evidence Amendment Act 2021 also was passed. This act, 2021 Amendment Act, brought about drastic changes in the definition of document under section 3 of the act, because by the time document contained only written and printed matters, but today, in view of advancement of science and technology, so many digital and electronic records came into existence. That is why, to cover WhatsApp messages, computer storages, CCTV footage, for all these things, this 2021 Amendment Act envisaged to expand the definition of this thing. And subsequently, in 2022, criminal law, Indian Evidence Amendment Bill 2022 was in progress. This bill brought about the in presumption of injuries during police custody, and this 2022 amendment bill wanted to add section 114 AA 114 AA after the 114A to Indian Evidence Act. But when the matter is pending, the Honorable Minister Amit Shah ji, Minister for Home Affairs, he presented a bill, in Bharatiya Saksha Bill 2023, along with two other criminal amendment bills replacing CPC, CRPC and IPC. And this evidence bill also was presented in August, but subsequently the bill was withdrawn, while second three criminal law amendment bills, namely this Saksha bill, Sanhita bill for this IPC, and Nagarik bill for this CRPC. These bills were second criminal law bills. These Bharatiya bills were presented in December, withdrawing the previous bills and were passed into law in the 2023 December. So, in simply, this Indian Evidence Act 1872 replaces is replaced by this Bharatiya Shaksha Adhiniyam 2023. But in view of practical implementation of the new Act Bharatiya Shaksha Adhiniyam 223, and this bill is passed in the middle of the academic year. We are following this, and for successful implementation of new enactment replacing Indian Evidence Act, there are so many practical constraints as revealed by concerned authorities and officials at present, although even in all educational institutions, that is centers of legal education and competitive centers, where the notification was issued by high courts for the civil judge juniors examination. They are following only Indian Evidence Act 1872. Even though the Evidence Act is likely to be replaced, but most of the provisions of Indian Evidence Act 1872 are being repeated in the new enactment. So there is no need to feel any tension, dear friends. Whatever was there in a previous enactment, the same will be repeated in a new enactment. But some cases, a few changes may be there, invariable in view of socio-economic changes. But whatever provisions are there in previous, they will be repeated in the new enactment. For example, in this preliminary in Indian Evidence Act contained 4 sections. In new enactment, it contained only 2 sections. In Evidence Act, Section 1, title extent application. First new enactment also same. Second, Section 2 in Old Act, Indian Evidence Act, repealing of enactments. Though this repealing of enactments, new act also is there, but it is placed in 170. So the Section 2 of Evidence Act became Section 170, Chapter 12. So one more chapter is added, Chapter 12, and one more section, a new Section 170 is given for repealing of the acts. So repealing of acts in repealing enactments in this means previous enactments of Indian Evidence Act. Repealing enactment for new enactment is our Indian Evidence Act. Like that, so many things are there. Yes, race guest Section 6 new Old Act, Section 4 new Act. Like that, everything, admissions are there, confessions are there, almost all provisions are there. But when once in today, Indian Evidence Act contained 167 section divided into 11 chapter, and additional sections are added, 20A, 53A, 111A, 112A, 113A, like that. So the additional sections of A, there are about 18 sections. Previously 167 section plus 18 section. The Indian Evidence Act contains 185 sections. The new enactment Bharatiya Shaksha Adhiniyam 2023 today contains 170 sections. The comparison between Old Act and New Act, I will tell you, but most of the provisions of Indian Evidence Act are being repeated in the new enactment also. So here in Indian Evidence Act 1872, Section 4 deals with may presume, shall presume, conclusive proofs. The may presume, shall presume, conclusive proofs are included in interpretation clause. So here, Indian Evidence Act, Section 1 title extent application, Section 2 repealing a fact, Section 3 interpretation clause, Section 4 may presume, shall presume, conclusive proof. The new act, Section 1 same title extent to application. Section 2 repealing act is Section 2 in old act. The repealing act is taken to end of the subject, that is Section 120. Therefore, Section 3 interpretation clause in old act becomes Section 2 in new act. So Section 4 pays presume, shall presume is there. These 4 items are included in Section 3 interpretation clauses only. So that is why 4 sections under preliminary became just 2 sections in new act only. That is the difference. May presume, shall presume, conclusive proof in Indian Evidence Act was discussed separately, but these 4 topics are included in interpretation clause only. This is what you have to remember. So now let us now discuss about about this subject. So introduction in the sense, first introduction, section 1 to 4, and other aspects we have to discuss, dear friends. Now, introduction, I told you the historical developments of Indian Evidence Act, and ultimately how it was passed. I told you, and at the time of passing, 167 divided into 11 chapters, one schedule, and today 167 sections, 18 AB additional sections, that is 185 sections without any scheduled today. So this is to be repealed and by the new enactment. Now coming to the evidence, with reference to introduction, the law which governs the relations between various countries in world, it is public international law. So public international law is there, private international law is there, private matters between various nationals, that is there in private international law is there. So marriage, divorce, adoption, maintenance, succession, transfer of property, all these things will come in private international law. State relations, so international conferences, all this will come in public international law. So the first subject is public international law regulates or governs relations between various countries. Next one is constitutional law. Constitutional law regulates the constitutional law is the law of a particular country. It is the nation's law. Is the law of the nation. So it gives direction, it controls, it regulates executive, legislature, judiciary, how executive should be, how legislature should be, how judicial should be, how laws are to be passed, what is the relation between fundamental, what is the relation between state and individuals, what are the rights, duties, obligations of individuals, what are the powers and functions of these 3 organs. All these things Constitution tells you. But Indian Evidence Act is law of the courts in India. So the public international law regulates various countries. Constitutional law regulates all organs in the state. So constitutional law is the international law is the law of the world. National constitutional law is the law of the country. But this Evidence Act is evidence, law of evidence is the law of courts in a particular country. So this is evidence is called law of this Evidence Act is the law of lex fori. Lex fori means the law of forum, the law of courts. So house of here in law there are in corpus juris, that is the body of laws, is divided into 2 parts. One is substantive law, second one is procedural law. Substantive law like IPC, contracts, transfer of property define various principles relating to rights, duties and liabilities of a particular individual. Procedural law defines procedure and mechanism how substantive laws are to be implemented. Whereas The law of evidence has the features of is law of pleading that directs, that governs how substantive laws are to be enforced. The evidence law is law of pleading. It gives guidelines, mechanism, organizational structure, how the procedural aspects are to be conducted in the court of law. So here, substantive law defines defines rights and liabilities. This law of evidence ascertains the rights and ascertains the rights and liabilities by examining the facts in issue. So this law of evidence, which is the law of pleading, also provides mechanism or organizational structure to implementation of the procedural laws. So that is why this evidence has relation with substantive laws and procedural laws, and hence this law of evidence is the law of all branches of law. All branches of law. So without a law of evidence, no branch of law can be functioned. So that is why I told you in previous class, the judge may decide the case without sources of law like legislation, custom, precedent, etc. But no judge will be able to decide the case without evidence, without principles of evidence. So that is the importance of law. That is why evidence is fluid for all laws, and evidence provides mechanism for substantive laws and procedural laws. That is the reason why the Indian Evidence Act, the law of evidence, has been described as the cornerstone of laws in a particular country. So not only in India, but every country, the law of evidence is a fundamental branch of law. It is cornerstone of any law in any country. So that is why Indian Evidence Act is described as lex fori, law of forum, law of courts. Now, this is about introduction of the evidence. Now, first section 1, coming to section 1, extent, application, and what is the title, extent and application. The title itself is very simple. The title of this act is Indian Evidence Act 1872. It came into force from 1st September 1872. At that time, it was this Evidence Act was applicable to India, Pakistan, and other. Even after partition also, it applied to both India and Pakistan. Even after independence of Bangladesh also, it extended to this. Now, at present, the Evidence Act is applicable to title is over, extent and application. To the extent and application, we can speak in two ways. Number one, the Indian Evidence Act applies to all judicial bodies, all judicial inquiries in all courts in India. That is all courts in India, including court martial. Court martial means military courts, army courts, except some court martials established by Army, Navy, Air Force Act. So it applies to court martials in India. It does not apply to court martials of this. Martial courts deal with war crimes, misconduct of military, Army, Navy, Air Force personnel. They are tried, they are punished. Even foreign nationals also for violating war crimes and other, they are tried in this. So the Indian Evidence Act applies to all judicial proceedings in all the courts, all the adjudicating bodies headed by legally qualified persons as judges. and it does not apply to non-judicial bodies. It does not apply to non-judicial bodies, and affidavits before court officer or court. It does not apply to arbitration proceeding. It does not apply to so many alternative authorities are there. They are not applied. So what is this? First thing, the Indian Evidence Act applies to all judicial proceedings. Judicial proceeding in the sense in an adjudicating body where the witnesses are examined after taking oath, or the witnesses are examined after taking oath only. For arbitration, conciliation, tribunals, law adalats and all, they need not follow the principles of law of evidence. It doesn't mean that they don't follow. They have the principles of law of evidence as per the principles of natural justice, principles of equity, good conscience, and this thing. So here in India, now what is judicial proceeding? What is non-judicial proceeding? If the proceeding, if it is the judicial proceeding is that proceeding wherein the court examines the witnesses after taking after taking oath. Secondly, the court is having authority whom to entertain, to give evidence, whom not to, who cannot be entertained to give in evidence. The court has the discretionary power. The court will entertain only relevant facts. What are relevant facts? What type of witnesses it can entertain? What type of witnesses it can declare qualified to be witnesses. So many discretionary powers are there in judicial proceeding. So judicial proceeding is an adjudicating body wherein legally qualified person will act as the presiding officer or the judge. It may be one judge or two judges or more than three judges with reference to High Court and the Supreme Courts. The Supreme Court. In subordinate court, there will be a civil judge or magistrate, and the proceedings are conducted as per the principles of law of evidence. But there are so many adjudicating bodies where cases are decided. The cases are decided in those adjudicating bodies, namely arbitration proceedings are there, mediation is there, conciliation is there, labor court is there, labor tribunal, national industrial tribunal is there, national tribunal is there, income tax tribunal, income tax appellate tribunals are there. So many tribunals are there. Administrative tribunals established under Tribunals Act, Tribunals Act 1985 is there, and other things are there. Those tribunals and other non-judicial bodies, there may be the law judge may be there, may not be there, but mere non-law judges will be there in these administrative tribunals. For example, in labor court, the judge is a labor commissioner or some executive officer. The collector is a non-judicial executive magistrate. Is an executive magistrate. He is not a legal qualified person. So like this. So in India, we have lot of pending cases. More than 5 crore cases are pending, reported. Unreported may be more. In order to reduce the pending cases, so many alternative methods were there. Family law courts are there. Consumer forum scheme, Lok Adalats are there. Gram Nyayalaya scheme. Tribunals are there, railway tribunals are there, industrial tribunals are there, fast track courts are there, ombudsmen are there. So many alternative measures. In alternative IADR, alternative measure, alternative dispute resolution subject, I uploaded good number of lectures, dear friend. They are very useful to, as a lawman, you must have knowledge. Apart from that, the constitutional law, administrative law, alternative dispute resolution, in these subjects, I have uploaded very good number of lectures. As an advocate, you must possess. I once again, dear friends, I want sincerely, honestly, consistently motivating you, inspiring you, stressing you to learn subject during student career only. First you follow you student career. Either you watch my lecture, attend classes regularly, so you can learn elaborately. By the time you leave the college and start your career as an advocate, you must have handsome law degree with wonderful legal knowledge. Only student career only you can learn the subject. When once you completed a subject degree without knowing, without having enough knowledge, when once you go to court, you won't be able to find time. So even after completing degree without having sufficient knowledge, it is not too late. You immediately join a competitive center where you can have lot of inspiration and enthusiasm. Though then you start reading day and night and learn more and more subject. Whether you get selected or not immaterial, but you will start reading again and again, because all the candidates work very hard, 10 to 12 hours and above. They know, having seen the performance of the co-part other candidates in competitive center, you will have enthusiasm to work hard. And secondly, the competitive center coaching center people will have a lot of experience. They are exclusively working full time for that. They will give crash coaching, they will give lot of mock tests and everything. With this knowledge, subject you learn subject from my videos in classroom, and learn the examination techniques and all these things there, so that essay reading, translation, all these things, the practical issues they will tell you, so that you will be able to get through the exam, get through judicial officer exam. Even if you don't get through by mistake or misfortunately, this entire knowledge will be very very helpful to you as a wonderful advocate in the court. So that is the reason why I am pressing again and again. I want to motivate you. Don't think that I am boring. So this is uh, first section. And extent. So the extent is the Indian Evidence Act applies to all courts, judicial bodies in entire country. It does not apply to principles of evidence not applicable to non-judicial bodies like affidavits. Affidavit means the deponent who is giving affidavit will give furnishes personal uh, facts only, personal facts only. And in case court orders him to prove any fact, he should prove it, but the principles of evidence need not be followed. When affidavit is given to court officer or before the court, these principles of evidence are not applied. Similarly, in arbitration proceedings, arbitrator means the purpose of arbitration proceedings is to decide the matter outside the court. Other, because court through court of law, it will be a lot of time taken will be there. That is why for quick, speedy and quick disposal of the cases, arbitration, conciliation, mediation, other things are there. Lok adalats are there, labor courts, consumer forums are there, family courts are there, fast track courts are there. These courts contain non-judicial officers. If they may some certain times some judicial officer may be there, retired person may be there. They are judicial officer. The law of principles of law of evidence are not followed there, but they follow only principles of natural justice, equity, good conscience only. This thing. However, these are the law of evidence applied to judicial bodies, not to non-judicial bodies like affidavits, arbitration, and Lok Adalats, and other things. It's not. I will tell these things in detail. Then, which areas it apply? It applies to all territories of India, state territories and union territories. What are these? There are 28 states in India according to Schedule 1 of the Indian Constitution, and 8 union territories. For 28 states and union territories, the Indian Evidence Act applies to all states, including including the state of Jammu and Kashmir. But from the beginning, the Jammu and Kashmir was given independent status. That is why in old books, except the state of Jammu and Kashmir was there. But in 2019, the reorganization of Jammu and Kashmir Act was passed, abolishing Section 370, where 370 gave independent status, autonomous status to Jammu and Kashmir. That autonomous status was discarded by Union government by abolishing 270. So that is why all laws we accept Jammu and Kashmir is deleted, and all laws today are applied to Jammu and Kashmir only. Jammu and Kashmir only. Even before that, if any act could be extended to Jammu and Kashmir prior to 370 abolition, because to that effect, Parliament should pass an act called Extension of Jurisdiction to Jammu and Kashmir Act. That also was I told last time. So today, Section 1, it is Indian Evidence Act 1872. It applies to whole India, comprising of 28 states and 8 union territories. It applies to all judicial bodies only, wherein the witness is examined after taking oath. So other bodies, non-judicial bodies, they decide. So it doesn't apply to affidavit. Indian Evidence Act doesn't apply to arbitrator. It doesn't apply to. It applies to court martials. All court martials it applies, and it applies to courts established under Indian Bahrain Act, but it does not apply to few Army, Navy, Air Force court martials established under Army, Navy, Air Force. There is a special category. This is the application. Repealing of acts. Repealing of acts means Section 2 of the Indian Evidence Act contains 3 clauses. 2 clause 1, 2 clause 2, 2 clause 3. According to Section 2, clause 1 of the Indian Evidence Act, before passing of the Indian Evidence Act, there was the British period was there, ancient Hindu period, and there were 3 periods of law. Ancient Hindu period, ancient Hindu law, ancient Muslim period, ancient Hindu Muslim law, British period. So what all before the by the time Indian Evidence Act came into force on 1st September 1872, what all the acts, whatever principles of law, what all law principles of law which were not embodied, which were not enshrined in rule, regulation, act, enactment. Okay. So if all rules of evidence which were not codified in the sense, all the principles of law, whether in Hindu period or Muslim period or British period, if the principles of law are not enshrined, not contained any act, enactment, regulation, etc., all those uncodified principles stand abolished, because this Evidence Act is codified law. Is accordingly those even though the principles of natural justice they were deleted, because why deleted? They were uncodified. Now we are giving codified enactment. That is why the principles of law which were not contained in any act, enactment, legislation, statute stand abolished, stand repealed automatically. That is Section 2, Clause 1. Clause 2, in British period, the Act of Council, Section 25 of the Act of Section 25 of the Indian Council 1861. The Act of Indian Council Act 1861, Section 25, gave legal status to some principles of law, to be enforceable. So, what all principles of law of evidence which were given legal status to be enforceable by Section 25 of the Indian Council Act 1861 also stand abolished under Section 2. Section 2, Class 3 contains the repeals schedule of the Indian Evidence Act. So what all, because actually there are some column 3 of schedule, there were some principles of law and evidence, they are to be deleted, but the schedule as a whole is deleted by the repealing act of 1938. So after independent Indian Evidence Act, so 28 amendments acts were there, amendment acts and adaptation order. In repealing acts also other repealing acts are there, but the repealing act of 1938, that is act number 1 of 1938, repealed the schedule as a whole. Suppose in Evidence Act today there is no schedule at all. Section 2 containing 3 subclasses deleted these old laws and schedule. No, the second schedule is over. Then third point we discuss about there are 20 words and expressions used in this Indian Evidence Act, and their meanings and definitions are given under the interpretation clause. This if every act or enactment any law which is codified, section 2 or section 3 deals with the words and expressions used and their definitions. Art Contract Act section 2 interpretation clause. Transfer of Property Act section 3 interpretation clause is there. Evidence Act section 3 is interpretation clause, but a new Evidence Act section 2 will be interpretation clause. So that is why there are so many items are there. What are these items? We have to discuss now. First one is before going to first one is court. And now before going to take up interpretation, we should know the meaning of Indian evidence. What is meaning? What is the evidence? What is nature? We have to do. The word evidence is derived from the Latin word evidentia or evidere, which means being clear. Which means being clear, to ascertain, to find out, to find out truth in a fact in issue, like this. The word evidence is derived from Latin word evidentia or evidere, which means like. So because the Evidence Act 3 points for the Indian Evidence Act applies to all court martials, that is military courts, except the court martials appointed by 4. That is the court martial appointed by the Indian Army Act 1950, the court martial appointed by the Naval Discipline Act 1957, the court martial appointed by Indian Navy Discipline Act 1934, and the court martial appointed by established by the Indian Air Force Act 1950. So the Indian Evidence Act applies to all courts martials, but the courts martial which were established by these 4 enactments is not applied. No, the Indian Evidence Act applies to Indian courts established under Indian Marine Act 1887. So these are the for what places. Now coming to the subject, before going to interpretation class, meaning of evidence. The word evidence is derived from the Latin word evidentia, which means being clear. So it means being clear. So there are, before evidence the matter is unclear, after evidence matter is clear. This is what I told you. If the dispute is there, when if a wife and husband, if you hear to wife how you think that husband is bad. When you hear husband's voice, wife is here. When both husband are brought before court with their supporting evidences, then the judge will be able to know who is right and who is wrong. So it is why that matter is done by court with the help of the evidence by the both the parties. So before evidence, the matter is not clear, confusing. After evidence only, the matter is clear. So that is why the court cannot give any judgment if the evidence, if there is no evidence, there is no proper evidence. There are several cases. Courts dismiss the case under the benefit of doubt, because if evidence is not there, there is no case, no judgment. So this is the here the law. The evidence meaning. There are three fundamental principles of evidence. So first one is, for evidence, the court will ask the witness to give evidence in few words. Come to the fact in issue, dispute in issue. Don't tell any cock and bull stories. Whether theft committed or not, tell that only. He is rich man, he is a poor man, like that, like that. Several times he committed theft, not that. You just come to, you should not waste court time. Whatever is to be given in evidence, you should be given in evidence in as short as possible. That is first point. Second point is, the best means of evidence should be produced. So best means of evidence produced means documentary evidence is the best evidence. Thereafter, oral evidence is the direct evidence is the best means. Because if anybody say I am qualified, I have a lot of experience, it is oral evidence. So if his experience certificates are shown, documentary. Yeah, I am postgraduate. If certificate is shown, one can easily believe. If he says that he is I am first class, they will not postgraduate first class. Nobody will believe. That is why the best means of evidence, the documentary evidence should be produced. Thirdly, hearsay evidence is no evidence. If you know, you tell. You cannot say that my friend told it is the my friend told that A has stolen B's motorcycle. That is allegation. If C comes to court and says that A stole B's motorcycle, how you know? Did you see? No, I did not see. My friend D told me that A stolen it. That is not there. But hearsay evidence also is having a lot of section 60. There are a lot of exceptions. Hearsay evidence also will be taken into consideration. That is there. Next point, third point, the fundamental principle. Second 2 points are there. Quid probandum, modus probendi. Quid probandum means two underlying principles. What to be proved, how to be proved. Quid probandum, modus probendi. Suppose you students want to go to some excursion. Where to go? Bombay, Delhi, Calcutta, south or north. That is where to go. How to go? By flight or air or road. Like this. So what to be proved? How to be. Quid probandum, what to be proved. Modus probendi, how to be proved. These are the two fundamental principles. So here, next coming to the point, the evidence, the definition of evidence. Section 3 in interpretation class gave definition of the evidence like this. All facts which the court permits or requires to be made before it by witnesses in relation to matters of fact under enquiry, such statements are that is. So this first, secondly, all statements that all statements including electronic records produced for inspection of the court. So whatever witnesses the court will present to find out the particular matter in issue, and what are the documents the court is entertaining to for inspection. These two lines say that the court is accepting oral evidence and documentary evidence. It is not covering so many evidences. That is the criticism. Because when the court certain matters need not be proved, there is a publicly established gazette notification. No witness should come. Court will have notice of it. So in some cases, court should take initiative to find out the information. So many third parties are required. Confessions are there. Admissions are there. Risk tested, dying declaration. So many various issues are there, but the definition is under given to law of evidence under section 3 is not exhaustive. It is very narrow definition that is there, but in there is another interpretation clause, proof, disprove, not proved, disproved, not proved. If you verify that, when we go in detail about the proof, non disprove, not proved, the concept of proof will cover so many things. So the court is having a discretionary power. What type of witnesses are to be admitted? What type of admissions are not admitted? Who can testify? What is the relevant fact? What kind of relevant fact should there? What are the circumstances? The third parties may be called to give evidence. What are the cases the court suo motu will take evidence from other sources, experts' opinion, confessions. Even outside court, so many witnesses give confessional statement moved to police officer not admissible, but section 727 it is also admissible. Various things are there while discussing the concept of proof. So that aspect will overshadow this criticism is what it was given. So this is the definition. Section 3 of the Evidence Act gave definition to gave definitions of so many items. Next, now the next question is whether there is the question is short question may be asked. The law of evidence is lex fori. So the law of evidence is lex fori. Lex fori means the word lex fori is derived from the Latin term, the law of the forum. Law of the forum. Like what do you mean by consumer forum? Consumer court. Law of forum means court. So this the law of evidence provides principles of law to all branches of law in a country. That is why the law of evidence is undoubtedly a law of all branches of law in a country. So this is in simple word, the evidence law is law of judicial system comprising of various branches of law. So that is why suppose in a case the evidence collected is one place, event occurred is another place, the law to be followed is the law of the land. Law of the land means the law of evidence of the law that particular land only, that particular country will be taken into consideration. There is a relevant case on the point. Nehrendu Dattu Mujumdar versus Emperor. In this case, what happened was an event occurred in UK, but evidence collected in India. But it was held that the evidence collected in India, that is Indian law, should be applied. So that is what is called the law of evidence. Law of evidence. So here. So section 2(1) of criminal procedure provides says that wherever the oath of office witness is collected, witness is allowed after oath. That is judicial proceeding. Other proceedings are only departmental inquiries like this. In the first topic I had to tell, forgot it. Now judicial, non-judicial, these aspects are over. Evidence, principles of evidence is over. So for what areas the evidence is not applicable to, Evidence Act is not applicable to affidavits, evidence is not applicable to tribunals, administrative tribunals, but industrial tribunals, section 7A, 7B of Industrial Dispute Act confers according to section 7A, industrial tribunal is established. According to 7B of Industrial Dispute Act, national tribunal is appointed. But according to section 11(3)(a) of Industrial Dispute Act, they may be treated as a court, and the proceedings may be deemed to be the proceedings of the judicial proceedings. But still, these all tribunals are not covered under judicial body, but they can follow, they have to decide the case as principles of the natural justice. However, there are some few exceptional cases. Election commission is there. The election tribunal, is deemed to be court, and the proceedings are deemed to be judicial proceeding. However, it is subject to representation of People's Act. Representation of People's Act. This is what it is. The section 2 also is. And another, in interpretation, there are so many items are there. Evidence we have told. Court is there. Fact, relevant fact, fact in issue, document, proved, disproved, not proved, electronic issues. All these things we have to pay. However, the best items I have to. There are 20 items, 20 topics in interpretation class. So we have to. I have already covered evidence, meaning, definition, kinds of evidence also we have to discuss. Now, coming to the next important topic is after court. The next one is court. Court includes all judges and magistrates and all persons legally authorized to take evidence except arbitrators, etc. What is the meaning of first item for discussion is in interpretation class? Court. Court is a court is a court is an adjudicating body which includes judges or magistrates and other persons who are legally authorized to take evidence. So court in the sense, while taking up the judicial proceeding, the evidence is to be collected after taking oath only. Then only it is a court. To constitute court, the oath of evidence should be collected on oath. That is the first requirement. It consists of legally qualified persons at the judges. Non-legal qualified judges should not be there. So that is the judges. So here, the authorities in Madhya Pradesh, Madhyasthan, Adhikaran, Adhiniyam, that is described, that is admitted as they take oath. They take evidence after they take witnesses. They take evidence from the witnesses after taking oath of office only. So that is why the authorities of Madhya Pradesh, Madhyasthan, Adhikaran, Adhiniyam, it is called court. But generally, only courts containing judges, magistrates, wherein the witness is collected from oath, they are also called courts. Others are not called courts. So etymologically speaking, the court was a king's darbar. King's darbar. Before passing in British period, when Britishers entered Indian soil, the king was there. King was issuing charters, royal charters. The king's courts were there. It is called king's darbar. King or queen was the hereditary monarch. King or queen was to rule. King or queen to rule. Then that is why they are king's courts or queen's courts. The king or queen was to decide the case. So that is so the court is an adjudicating body. The court is an adjudicating body presided over by legally qualified judge or magistrate. So this is the admission meaning of court is over. Next, fact, relevant fact, fact in issue. Fact, relevant fact, fact in issue. So I already told this matter. Anything, state of thing, relation of things, capable of perception. And third one, any mental condition which a person is conscious. So fact means fact. Fact means absolute truth. Fact means absolute. I am a man. This is the table. This is the chair. This is house. That is river. These are the facts. They are physical facts. Physical facts means external facts. External fact, physical fact means they can be identified by senses. 5 senses of human being: nose, ear, eye, tongue, and skin. These are the five senses. With five senses, we can say closing your eyes, you can touching with this is water, this is cold water, this is hot water. You can tell. That is physical fact. Mental fact means that man has a lot of reputation, and you can see a man outwardly he is very healthy, but inwardly he is suffering from cancer. That is a mental fact. Psychological fact. Physical facts mean by looking, by seeing, by touching, by smelling. If whatever you can identify, they are physical facts. But without with physical facts, with senses, things we cannot identify are called mental facts or psychological facts. Suppose we can see a man, two boys are going, you can tell. Two law students are going means that is mental fact. Mental fact. Whether a good man or bad man. So bodily feelings, menstruia, fraud. These are the items. So depending on these things, the mental facts can be detected. That is fact is over. Physical fact, mental fact. Fact. What is relevant fact? Relevant fact means there must be a connect. If there the connection, there should be connection between two things. One fact becomes relevant to another if there is a causal connection between the both the two. He is a qualified means he is a qualified man means he has a lot of his degrees are relevant. He is qualified means his degrees are relevant. He is a good man. His contribution is relevant, like that. This relevance also I told in the previous class: logical relevancy, legal relevancy. Legal relevancy is enforceable. Logical relevancy is not enforceable. For example, husband's duty to feed wife and children is legal. Husband's obligation to purchase diamond necklace to wife, motorbike to son is not legal. It is logical. Only legal obligations are enforceable. Logical obligations are not logical facts are not enforceable. Legal. Third one is fact in issue. Fact in issue means a dispute in issue. Suppose A lent the 1 lakh to B. A says that I lent him. B says that he did not lend me. So when there are two opposite views as to relating to a fact, that becomes a fact in issue. That becomes a fact in issue. Similarly, wife and husband. Wife and husband were dispute may be there. They are legally married. One says legally married, other says not legally married. So there are so many things. So fact in issue is a fact, means a fact in dispute. One says yes, other says no. Whether A says yes, no, B says no. Whether it is right or not, we can do. So in a particular fact, certain questions may be arose. The questions that emerge from facts are called facts in issue. The facts in issues may be affirmative or negative on proof of the facts. So depending if the fact is proved, one party wins. One party proves means the fact is disproved by other party. They take court for taking into consideration the witnesses. What are the while entertaining the fact, the court will take into consideration it must be relevant fact. The fact is said to be relevant according to section 5 of the act, and there are various instances of relevancy under section 6 to 55, and who are qualified, who can testify, and who will be allowed to qualify, who will be allowed to come and give evidence. Those aspects the court will decide who will have to prove under section 56 to 100, and the mode of proving the court will entertain examination of witness, cross examination, all these things the court will entertain under section 101 to 167. So these facts, after arriving at these facts only, the court will come to a conclusion whether it is proved or disproved, and will deliver judgment accordingly. This is what is called fact in issue. For example, A killed B. A killed B. B died is a fact. A killed, whether A killed or not. Okay, A killed is fact. B died is fact. But whether A intentionally killed, if A intentionally killed B, it attracts a section 299 or 300 IPC. He will be sentenced to life imprisonment or death sentence. If he committed a negligent accident under section 304, 304A, he will be punished under section 300. If he will be punished under section 304A, he will be imprisoned up to 3 years imprisonment and fine or both. Suppose while A killed B is correct, while driving the vehicle, some pig or buffalo entered suddenly, he won't be able to control, and a bystander was killed. That is inevitable accident. He is exempted from liability under section 80, chapter 4 of Indian Penal Code. Suppose that the A, he was an entire A was mental, insane. He was unsound. He was not able to know what is right and wrong, and he drove the vehicle. He entered into vehicle and drove the vehicle, started the vehicle and drove it and killed the surrounding people, as if happened in a Swargate bus stand in some Pune. Then they established insanity. So what is the case? So if an insane person committed, he can plead exemption under section 84 under chapter 4 of Indian Penal Code. These are the various facts in issue. Keeping in mind the facts in issue and answers and practical issues, the court will come to a conclusion whether how the judgment is to be given. So fact in issue is a matter in dispute between two parties, wherein two parties profess to opposite views relating to existence of the fact. From answering the questions to facts in issue, the case will be decided. So the relevant fact in issue is over. And next one is document. Next one is document. Next one is Section 3 of Indian Evidence Act deals with document. So the document, first para deals with document includes all material substance on which documents. So the document is the best means of evidence is documentary evidence. One of the fundamental principles of law of evidence is documentary evidence. Section 291, Section 29 Indian Penal Code, Section 3, Clause 18 of General Clauses Act 1897, and Section 3 of Indian Evidence Act define the documentary evidence. Documentary evidence means a written, if it is an evidence by means of piece of paper, either it is written or printed in some permanent nature, that is documentary evidence. And in the view of electronic advancement, all electronic records, signed or unsigned, computer storages, WhatsApp messages, telegrams, all these things come within the meaning of document. Section 61 to oral evidence means statements given by the witnesses in court. They are oral statements. The oral statement is direct evidence. In the absence of oral statements, hearsay evidence may be accepted by the court sometimes, but section 5960 of the Indian Evidence Act deal with oral evidence. Section 61 to 90A of Indian Evidence Act deal with documentary evidence. There are various instances of documentary evidence, but this documentary evidence, in the sense, whatever is inscribed in paper, metal, or paper, metal, or any material in some permanent form, in that material by which the human by which the thoughts of human being, thoughts of man are represented. Suppose the foundation stone, whatever is contained, that is the document. CC cameras, CC camera footing, CC camera footing, all these things, they come within the meaning of document. Suppose statue is there, it is in permanent form, it come within that meaning. And whatever letters or pictures, maps, everything, they are inscribed in a particular material wherein the feelings and thoughts of the human are inscribed. They come within the meaning of this thing. And the Indian Evidence 2022 bill, the Indian Evidence Amendment Act 2021 covered all these aspects so as to establish the meaning of the document. So, document, this is the position of meaning and meaning of the document. So, oral evidence is over, documentary evidence is over. So, we can say that oral evidence is one type of, there are different kinds of evidence we have to see. One is direct evidence, indirect evidence, real and personal evidence, original and hearsay evidence, primary and secondary evidence, oral and documentary evidence, circumstantial evidence we have to say. Direct evidence. What do you mean by direct evidence? The evidence given by the eyewitnesses that I have seen A killing B, that is direct evidence. So the accused tells in court, I have committed that murder. That is direct evidence. So the accused makes a confessional statement to police officer. It is not allowed under section 25. If he tells that I have killed somebody in the presence of magistrate in police custody under section 26, it is admissible. That is direct evidence. There is no further inquiry. Suppose in police custody, the accused said, I killed so and so and kept him in my garden, buried him in my garden. If you ask me, if you take me, I will show you the body. Then it is direct evidence. Direct evidence means it may be direct eyewitnesses evidence, or it may be direct production of document, original document evidence, or statement, confessional statement given, or admission given by the defendant in the civil court. All these come within the meaning of direct evidence. Indirect evidence. In the absence of direct evidence, the court will go for indirect evidence, that is presumptions and other things. Indirect evidence. Section 6, when a crime is committed, after committing the crime, he will run away. In such cases, the court will take into consideration indirect evidence. Indirect evidence means A said B for 1 week back, within I will kill you. A said B that A would kill B. This statement was made 1 week back, and accordingly B died and floating on the river. And who killed him, nobody knows. But some bystander said, sir, a few days back, so and so said in presence of public that he would kill A. Accordingly, he died. So that is what is called indirect evidence. The indirect evidence also refers to circumstantial evidence also. Next, real evidence and personal evidence. Real evidence and personal evidence. Real evidence means it can be perceived by senses. Real evidence can be perceived by senses. For example, blood-stained clothes are left over, and the chain of the while committing rape, the chain of the accused was found on that. The shoes of the accused were found on that, or some belongings of the accused were found on that particular this thing. That is real evidence. Suppose a human being died. Who killed it? The footprints of some animal, tiger or lion, are there on the sand. That is they are called real evidence. Real evidence. So the evidence can be identified by perception only. That another thing is personal evidence. What do you mean by personal evidence? If evidence given by human beings is personal evidence. Original Original evidence, hearsay evidence. Original evidence means eyewitness. I have seen that offense. I saw A stole B scooter. Hearsay evidence means not directly. A stole B scooter. She is telling. Have you seen? She said, no, I did not see. My friend, my roommate D said A stole B scooter. That hearsay evidence is not allowed. The fundamental principle is hearsay evidence is not admissible. But however, there are certain circumstances in case of res gestae, dying declaration, and other crucial issues. This hearsay evidence also will be considered by the court depending upon the circumstances. Oral evidence to documented evidence I have already told. Section 70, 59 and 60 deal with oral evidence. 61 to 98 deal with this thing. Circumstantial evidence. Circumstantial evidence is the indirect evidence otherwise. So circumstantial evidence, the accused can lie, but the circumstances will not lie. The circumstantial evidence means generally when crime takes place, the culprit run away. Run away will be absconded. The court will find out all means and adopt all means to find out the person. So this circumstantial evidence we come across in this is relevant to res gestae section 6, dying declaration 32, and other aspects we have to follow. So these are the various kinds of evidences also I have covered, and the last one is proved, disproved, not proved. Proved means when fact in issue, when a fact in issue before the court will examine various things. In first thing, the person who wants to present a matter before the court, basically it must be a fact, he must be an existing fact. It must be a fact, it must be an existing fact. Secondly, it must be relevant fact. Thirdly, it must be otherwise relevant within the meaning of section 6 to 55 of the Act. Then only the court will entertain. In this connection, the court suo motu shall take notice of certain facts. These certain facts need not be proved. Some third parties may be called. The court will decide who is qualified to give every witness, whose witnesses the court can entertain. All these things, the court will decide whether a particular person is qualified to give evidence or not, and whether a particular person's evidence is necessary or not, and whether third parties are to be called, and so many issues. The court will exercise discretionary power to entertain these things. After taking into consideration all aspects, the court will come to a conclusion that the particular fact issue in favor of somebody, the court will decide the case, and the case is said to be proved. If taking into consideration all these issues, the court comes to a conclusion that it is not correct, it does not exist, and the court will reject. Then it is called disproved. So this not proved is negative to prove, and it is neither proved nor disproved. So these are the meanings of proved, disproved, and not proved. So the definition of proved will remove the controversy or criticism of narrow definition under section 3. The definition of is given under section 3 is interpretation clause 22 definition, but the elaborate definition can be had from this concept of proved. And the last section 4 speaks about may presume, shall presume, conclusive proof. This topic I had already first 3 classes I explained, and in summary also these 3 points I have explained. So now anyway I will complete this also. May presume, so presumptions. Presumptions means somewhat assumptions, guessing. Suppose when a crime is committed, the accused will run away. Similarly, in civil matters also, the defendant will try to escape the liability. In the absence of absolute truth, the court will go for presumptions. Presumption. So and so, from this time to this time, the person is expected to be in office. If he is not in office, he is in club. Not in club, he is in some friend's house. That is how we have to presume it. Suppose when you see the vehicle of your friend in front of a hotel, you think that your friend has come into that hotel. So when his vehicle is outside, you presume that he is inside. That is the presumption. Sometimes he may bring the vehicle, or his wife may bring the vehicle, or friend may bring the vehicle. So it may be or may not be. So it may be correct. So still we should have some clue. We need some clue, because the culprit should not run away. Culprit should not run away. So the person who has to meet liability should not be freed from liability. For this purpose only, in the absence of truth, absolute truth, the court will resort to presumptions. Presumptions means presumption means this is. So he is not in classroom means he is in library. He is not in library means he is at home. There are the presumptions. It may be right or wrong. Now, these presumptions are three categories: may presume, shall presume, conclusive proof. May presume, first one is presumption of fact or natural presumption or artificial. Presumption of first one is, presumptions are basically two. Say presumption number two is subdivided into two. First one is natural presumption or presumption of fact or may presume. So in such particular case, the court will have complete discretionary power to decide in any way. Any way. Suppose a person in possession of gold is suspected and arrested by the police and placed before the magistrate. Now there are three chances. Whether the gold is stolen property, whether A, accused, whether he has stolen the property, the court may consider after hearing the argument and find him guilty under section 379 or 379A and give punishment for theft. Or the court may declare him he purchased stolen property, which is an offence under section 410A, and he may give award, he may be awarded punishment under section 411. That is there. The court may declare he is not neither stolen nor stolen property. He is the real owner, as in the case of Kasturilal case in law of torts. Then he may be acquitted. So that is what is called natural presumption or presumption of fact or may presume. Second one is shall presume. Shall presume. Second one is presumption of law or artificial presumption. Presumption of law or artificial presumption is second one. The presumption of law or artificial presumption is two categories. One is rebuttable presumption and challengeable, disprovable, and irrebuttable and not challengeable, not disprovable. Presumption of law or artificial presumption, and in this there are rebuttable, challengeable, disprovable. That is shall presume. Shall presume. Suppose when a document is published, the court shall presume it true. If degree certificate is produced, the court shall believe that, the court shall presume that it is genuine. If any gazette notification is there, the court shall believe that it is genuine. It is genuine. Then the court shall presume. Suppose with regard to a dispute relating to housing tax, the court submitted the tax returns etc. submitted by the party, the court may believe as genuine. Suppose the government gave notification converting that area, panchayat area into municipal corporation, then the rates of the land will be there will be a substantial hike in value of the property, commensurate hike in taxing also. So if any notification, subsequent notification is produced, it can be disprovable. Suppose the degree certificate also can be disprovable as a certificate, because the university has taken decision to disqualify the degree where mass copying took place, and that notification of that effect is shown, the court shall presume it can be rebuttable. This is the thing. The last one is presumption of law, or artificial presumption, or irrebuttable presumption. Irrebuttable means cannot be challenged, cannot be disproved. That is conclusive proof. Conclusive proof. Where the court has come to a conclusive proof, it will not accept any more argument. It will not accept any evidence to disprove it. Disprove it. Suppose the district court issued decree of divorce to couple. If they say want to try to rebut it, one of the party wants to challenge it, the court will not accept. If at all they want, then immediately within the limitation period, they may approach the higher court to challenging the decree of divorce given by lower court, but they cannot. So until then, the court, if the time is elapsed, a decree of divorce granted by court is there, the court must come to a conclusion that it is a conclusive proof. It is a conclusive proof. So similarly, for legitimacy of a child, if wife claims legitimacy of a child, but husband tells that I was in out of country for the last 3 years, and then it will be a conclusive proof the wife will not be allowed to prove anything. So if if within 128 days pregnancy comes, the child is presumed to be legitimate child, but still the husband may challenge that though it is I'm living together, but I did not cohabit with my wife. The child was born due to somebody, and illegitimacy can be challenged. To that effect, DNA test may be referred. In such case, the court shall presume within the child is born within, and once it is challenged, DNA certificate gives certificate in favor of the husband, and the child is born to somebody other than husband, that the court will decide it as a conclusive proof. These are the issues with reference to may presume, shall presume, and conclusive proof. Dear friend, I have covered these preliminary aspects 1 to 4. In next class, I will take up section 6, 5 to 55 contents, introduction, and section 6 res gestae, and followed by 3-4 sections. Thank you very much for your patient hearing.